I grew up in that cabin, not the cookie-cutter vacation houses that dotted the lakefront, but the one my grandfather built by hand, timber by timber, after World War II. The smell of pine and cedar was embedded into the walls. The floorboards groaned like old friends, and the creaking of the porch under my weight always felt like it was whispering secrets only I could hear. Summers were filled with fishing lines in the lake, late-night fires under the stars, and my grandmother's stories about how the county had tried to take the land more than once, and how my grandfather had fought them off. By the time I inherited the cabin, I knew every inch of it, the way the sunlight hit the kitchen in the mornings, the slope of the dock that my father had repaired each spring, even the little trapdoor in the floor that led to a hidden storage room no one but family had ever opened. It wasn't just a house. It was a legacy, a promise that no matter how much the world changed, something in this corner of the county would remain mine. That was, until the Homeowners Association showed up. The HOA had always been a shadow hovering at the edges of my life, nagging about rules that didn't exist in my grandfather's day, fence heights, dock dimensions, paint colors that didn't match the approved palette. At first, I laughed it off. They were bureaucrats in polos and khakis, convinced that their annual meetings and stacks of printed regulations made them king of the lake. But the jokes stopped when the first warning letter arrived. A thin envelope with my name, threatening fines for improperly maintained grounds and unpermitted structural modifications. I read it twice, then tore it up. I knew my cabin better than anyone else, and I wasn't about to let a group of self-important amateurs dictate how I lived on my own property. I figured they would give up eventually. After all, they had bigger houses to worry about, HOA meetings to attend, and cocktail parties where the only danger was someone spilling wine on the new carpet. Then came the day they sent the bulldozers. I was sitting on the porch, coffee in hand, when I noticed the trucks rolling up the dirt road. At first, I thought it was a neighbor doing some late summer landscaping. Then I saw the words on the side of the machines. Authorized by HOA name, county permit, dar XXXX. My stomach sank. I grabbed the binoculars and watched as men in hard hats circled my cabin, snapping photos and marking the ground with fluorescent paint. I ran down the steps, yelling at them to stop. The foreman smirked and waved a laminated piece of paper at me. "Permits in order," he said. "We're just following legal orders." Legal orders. They were demolishing my family's cabin. My blood ran cold, but my mind went into overdrive. I couldn't just stand there. My grandfather's cabin wasn't just wood and nails. It was a testament to decades of resilience, stubbornness, and survival. And if these people thought they could erase it with a few bulldozers and a permit, they were in for the shock of their lives. As the machines roared to life, I realized something crucial. I had more leverage than they could ever imagine. Years ago, quietly and carefully, I had started acquiring legal rights that no one in the county seemed to notice. Minor deeds, easements, historic preservation filings, even obscure liens on abandoned lots. At the time, it was more curiosity than strategy. I liked knowing I had an invisible web of influence that stretched across the county. I didn't think I'd ever need it. I just liked being prepared. And now, as my cabin splintered under the steel teeth of bulldozers, I knew it was time to use that preparation. The HOA didn't know it yet, but I was about to turn the tables in a way that would leave every board member questioning their own reality. By the time I drove into town later that day, I had a plan forming in my mind. I would start at the courthouse, combing through public records and legal filings. I would document every overreach, every permit issued without proper authority, every loophole in the HOA's bylaws. And when I found the right leverage, I would hit them where it hurt most, not just with words, but with the law itself. They had assumed I was powerless. They had assumed that a cabin owner alone, isolated and stubborn, could be brushed aside like a piece of unwanted debris. They had assumed wrong. That night, sitting in a rented motel room because my cabin no longer existed, I opened my laptop and began mapping out every legal claim, every document, every little hidden advantage I had accumulated over the years. By the time the sun rose, I had a single goal etched into my mind: make them pay, and make sure they knew exactly who they had underestimated. Justice was coming, and it wasn't going to be subtle. When the sun came up the next morning, it felt wrong, like a stage light that had been left on after the play. illuminating the wreckage that used to be my life. I drove back to the lot before the county crews had finished hauling away the last of the splintered beams. Yellow caution tape fluttered in the wind around a mud-scarred rectangle where the porch used to be. My father's fishing rod lay half-buried in a rut like some relic washed ashore. Neighbors peered from behind curtains and from the safety of their own manicured lawns. Their faces a mixture of curiosity and the private relief of people who tell themselves they would never be the next headline. My hands shook when I pulled my phone from my pocket. There was a blankness to my voice when I left messages for friends and relatives. The words came out steady but distant, like a radio broadcast from another town. I told them what had happened. I told them the HOA had bulldozed the cabin. They said the right things: outrage, sympathy, offers to help. But beneath their concern I could hear the same question my grandfather had heard in his day. What can you do alone? They meant it kindly. They didn't know that alone. I wasn't helpless. I was dangerous in ways they couldn't see. The courthouse is a 2-hour drive from the lake. A squat building of red brick and fluted columns that smells of paper and lemon cleaner. Its public terminal room hums with fluorescent light and the low thrum of strangers tapping at keyboards. I had spent more than a few evenings there over the years, mostly out of idle curiosity and a perverse fondness for bureaucracy. Old maps, chain of title records, liens filed on forgotten parcels. I'd taught myself how to read them like other people read novels. There's a certain rhythm to the pages. Names repeat, ink fades. The same clerk stamps like a metronome. To most people it's a maze. To me it had become a map. The first thing I did was pull the demolition permit. The county keeps permit files in meticulous order: application, blueprints, signatures, and a notarized chain of custody for any approvals. I wanted to know if the HOA had actually bypassed protocol or if the county had been an accomplice. When I opened the file, I expected errors and sloppiness. Instead, I found a clean bureaucratic trail that looked almost antiseptic. Permit number, issuance date, name of the inspector who signed off, a scanned copy of a consent form from the HOA. The foreman at the site had not lied. The permit was, superficially, in order. But the permit didn't tell the whole story. As I dug deeper into related filings, a faint inconsistency surfaced like a hairline crack running through marble. The consent form was signed by the HOA president, but the president's signature on the bylaws amendment, the one that supposedly authorized demolition of non-compliant structures without direct homeowner notification, had a different slant. The notarization? It had a stamp from a notary who had been on maternity leave during the dates listed. Little, almost innocent discrepancies, enough for a careful eye to notice, and enough for a determined one to pull loose the stitching of a tidy lie. I started printing everything: chain of title on the cabin lot, historic easements, a preservation filing my grandfather had once put in to protect a grove of shoreline pines, old floodplain maps, the HOA's charter and subsequent amendments, copies of emails I'd managed to subpoena. Yes, subpoena, a phrase that felt audacious to type, that revealed hurried exchanges between HOA board members and some outside contractor. They were polite, efficient, and full of presumption. They treated the cabin like a scheduling problem, not a human home. What surprised me more than the sloppy consent forms were the names I kept seeing in the margins of so many documents: small municipal corporations, shell companies, and a scattering of dormant LLCs that seemed to appear only when the HOA needed to obscure a payment. It's amazing how often money prefers shadowed corners. I made a list with column headers: name, relation to HOA, linked properties, last known address. I felt the old thrill of discovery, the same feeling I'd had as a kid finding an arrowhead beneath the dock, but sharpened by resentment. The deeper I went, the more I understood that the cabin was a symptom of a larger rot. The HOA serviced an ecosystem of interests: contractors who got repeat work, developers looking to consolidate lakefront parcels, board members who had quietly swayed zoning variances in exchange for consulting retainer fees. None of it looked illegal on the surface. It was more insidious: legalized capture of a small local government by social and financial influence. There was one thread, however, that made everything click. It was an innocuous easement from 22 years ago, filed by someone with a name I recognized, my own. I froze when I saw it. The filing was minimal, a notation granting shared access to a narrow strip of shoreline for the purpose of docking small watercraft. The language was spare and precise. My name appeared as grantee on the easement. I had no memory of signing it. For a moment I felt the world tilt. Then I remembered. Years earlier, between odd jobs and the slow months, I had taken on small legal research projects for people who couldn't afford a lawyer. I would look up titles, draft simple filings, and in return the clients, grateful and often elderly, had slipped me small favors: a case of peaches, a night to sleep in an empty cabin, or once the notarized name of a relative who owed me a debt. At the time it had seemed ordinary, neighborly. I'd never imagined those favors would be the raw material of a future reckoning. I printed the easement and compared the signature to my own. The handwriting was mine, not identical, shaped by different pens in different years, but undeniably my hand. That meant two possibilities. Either I had signed and forgotten, or someone had forged my signature. The first felt unthinkably irresponsible. The second felt criminal, and more importantly, actionable. I took the easement to the county clerk and asked for the file's history. There it was, an amendment that reclassified several parcels around the lake, filed the same year the easement was recorded. The amendment had allowed for community-managed shoreline improvements, language as vague as fog, and a footnote that permitted the HOA to authorize emergency removal of structures deemed hazardous. Suddenly, the demolition permit didn't seem like a lone act of bureaucracy. It fit into a legal scaffolding erected years ago, deliberately ambiguous and ripe for interpretation. If the HOA had manipulated ambiguous language to justify demolition, then someone, perhaps a cadre of board members and contractors, had systematically converted those ambiguities into power. I felt sick with the precision of it. This was less an isolated incident than a method. Create vague bylaws, accumulate influence in the right municipal chairs, then act decisively when the political winds turned in your favor. Returning to my motel that night, I realized I had two operating avenues: the obvious courtroom path and a more surgical, leverage-based strategy. Lawsuits are expensive and slow. Public humiliation is messy. But documents? Documents are the skeleton key to power. If my name, for whatever reason, appeared on multiple filings throughout the county, then I might already possess legal hooks the HOA hadn't accounted for. The easement was the first. Over the next week, I stopped sleeping normal hours. I lived in the courthouse, in the office of a retired title clerk who took pity on me and allowed me to scan boxes of dusty maps. I interviewed old neighbors, gathered affidavits, and assembled a timeline so granular it looked like a crime scene board. I began to map links. Which board member had previously sat on the planning commission? Which contractor had donated to the county supervisor's re-election campaign? Which shell company had purchased a string of lots around the lake and then left them fallow until rezoning made them valuable? It all looked like a puzzle of greed and inertia, and then a pattern that made my heart race. My name was not only on that old easement. Buried in a stack of scanned, half-forgotten documents was a quiet, unglamorous deed. A small conservation covenant filed in an adjacent township. Another document, a release of certain riparian rights on a property 2 miles down the shore, also bore my name. Many of these filings were minor, nearly inconsequential on their own, the sort of bureaucratic footnotes a clerk might miss. Taken together, though, they formed a lattice, a legal lattice that, if tightened and wielded properly, could be used to place constraints or assert claims across the county. My small, almost careless acts of assistance to neighbors had, over time, yielded a strange portfolio of legal touchpoints. Each one individually was unremarkable. Together, they were a network. The realization arrived with a cold clarity. I hadn't been careless. I'd been building, without meaning to, a map of leverage. Perhaps not intentionally engineered for revenge, but the tools were there. It was as if the county had given me deposit slips for an account I didn't know I had, and now that account had a balance. Armed with this revelation, I shifted my tactics. Instead of charging headlong into a single lawsuit, I opened multiple small files and letters, each precise and procedural: a request for an audit of the HOA's permit process, a notice to the county recorder questioning the notarization on the demolition consent form, a formal preservation claim invoking the language in my grandfather's old covenant. I filed mechanics' liens where the contractor's invoices looked suspiciously inflated. I requested copies of communications under public records law, and when answers were slow, I filed follow-up petitions insisting on expedited review. There is a delicious cruelty to bureaucratic procedure when you know how to use it. The county, which moves at a glacial pace when left to its own devices, becomes an engine of pressure when you feed it well-placed, proper paperwork. I sent letters, copied to county supervisors, local newspapers, and prominent attorneys who specialized in municipal law. My requests were clinical and methodical. They didn't accuse without evidence, but they demanded that evidence be produced. That's the thing about bureaucracy. It hates being asked direct questions, and the HOA, for all its bluster, had no idea what was coming. They continued to hold meetings, to pat themselves on the back for efficient governance. They sent out memos about community beautification and planned barbecues. They assumed the storm was over and life would resume. Meanwhile, the files on my desk multiplied. The breakthrough came when a clerk in the recorder's office, a woman with a soft voice and a habit of finishing other people's sentences, called me in a whisper. "You need to see the digital submission log," she said. "There are uploads tied to one of the HOA email addresses, but the IP trace points to a commercial account. And this notary stamp, it was used on 3 different documents on the same date, all filed within minutes." Her tone was half confession, half concern. She directed me to a set of scanned images that showed something the naked eye might miss. The photocopy of the notary's license had been slightly stretched, the margin misaligned as if copied from another page and pasted. It wasn't proof of forgery, not yet, but it was enough to demand scrutiny. I printed those images and put them on the center of my table like a center cut of meat. Everything else, the easements, the liens, the chain of title irregularities, orbited around that one suspicion. If the notary stamp had been faked, the demolition consent might be void. If the consent was void, then the act of demolition could be legally interpreted as an illegal taking, or at least an actionable trespass. If I could show pattern and intent, if I could connect the notary to the HOA's inner circle, there would be consequences beyond restitution, civil penalties, potential criminal charges for fraud, a cascade that would make the board members' comfortable lives uncomfortable in ways they couldn't ignore. I had the beginnings of a plan. Keep the pressure surgical, precise, and unshowy. Let the county's own processes do the heavy lifting. Demand records in ways that force the bureaucrats to either comply or contradict themselves publicly. Build a narrative that combines sentiment with ironclad legal facts. And above all, stay patient. The next morning, I mailed a formal request to the county prosecutor's office, attaching the anomalies and the pattern of documents that linked HOA action to questionable filings. I wrote with the dry tone of someone who knows where the lines are and intends to make sure everyone else stays inside them. And then I waited, not passively, but ready to strike with the next carefully prepared motion when the county's reply opened the smallest door. They had demolished my home and thought they'd erased me. Instead, they'd revealed the very seams in their own system. I felt, for the first time since the machines had started their work, a cold satisfaction. The fight had moved from the muddy lot beside the lake to a place where words and ink mattered. And ink, not concrete, had become my weapon. By the time the county's first response arrived, I had spent countless hours staring at spreadsheets, maps, and scanned documents. The pile on the motel table resembled a small fort, each folder a bastion of potential leverage. I realized the fight would not be won by brute force or shouting matches. It would be a war of patience, precision, and psychological pressure. Every action, every letter, every filing had to be meticulously calculated. I started with the board members individually. Using public property filings and previous HOA meeting minutes, I created dossiers on each one, their property holdings, mortgages, liens, and even minor easements they might have overlooked. It wasn't about vindictiveness, and not yet. It was about preparation. Knowledge was power, and the more I knew, the tighter the net I could weave. I wanted them to feel the same creeping unease I had felt when I first saw the bulldozers approach my cabin. The realization that someone could dismantle their sense of security piece by piece. Next, I scrutinized every county regulation the HOA relied upon. Permits, bylaws, historic preservation rules, all of it. I needed to identify every ambiguity, every loophole, every clause that could be turned back on them. By cross-referencing decades of filings, I uncovered obscure precedents. Cases where minor errors or oversights in permitting had resulted in significant penalties. I bookmarked these, printed copies, and annotated them with the cold, precise calculations of someone preparing for a chess game where every move mattered. Then came the creative part. I devised a three-pronged strategy: legal pressure. Using my knowledge of loopholes, I drafted motions, petitions, and requests that forced the county and the HOA to respond publicly. Each response, each official record, became evidence, a breadcrumb in the trail I was leaving for eventual leverage. I ensured that no reply could be brushed aside, no signature unexamined, no process unmonitored. Financial leverage, the liens and covenants I controlled, combined with minor parcels of land my name appeared on, gave me the ability to threaten financial exposure. Small claims could cascade into larger claims. Easements could restrict development. Conservation filings could halt projects. It wasn't about greed. It was about ensuring they understood that their overreach carried real consequences. Psychological warfare. I let subtle pressure build. I sent letters that seemed routine but hinted at larger investigations. I copied multiple county offices, creating a sense of scrutiny. I knew from experience that the mere perception of oversight could unsettle even the most confident board members. I also revisited my grandfather's old notes and letters. There was wisdom there, patience, observation, and the art of using an opponent's assumptions against them. He had written about the dangers of underestimating someone who seemed passive, the hidden power in silent preparation. His words became my blueprint. One night, after hours of scanning documents and drafting motions, I realized something important. The fight was not just about the cabin. It was about setting a precedent, about showing that a single individual, armed with knowledge and patience, could challenge a network of complacent authority. If the HOA believed they could act with impunity, it was time they learned the lesson the hard way. I began coordinating with allies, lawyers who owed me favors, neighbors who had quietly suffered under the HOA's petty tyranny, and even a retired county clerk who had grown disillusioned with bureaucratic shortcuts. Each was briefed carefully. Each had a role. I wasn't building an army. I was building a machine, precise, calculated, and silent. Drafts of letters became a ritual. I would write, edit, and then wait, imagining the faces of the board members as they opened envelopes and read my careful, almost clinical prose. Each letter suggested oversight, investigation, and potential legal consequences without overt threats. The subtlety was key. I wanted the anxiety to seep in gradually, like water eroding stone. Meanwhile, I expanded my network of documents. Easements, liens, minor covenants, things the HOA hadn't accounted for, became my arsenal. I filed new claims where possible, resurrected old rights, and connected them in a lattice that spanned not just the lakefront but the surrounding parcels, demonstrating my influence across multiple jurisdictions. By the end of the second week, I had a digital map that could trace my legal footprint anywhere the HOA had interests. And then, just to test the waters, I sent a carefully worded inquiry to the county inspector who had signed off on the demolition. It was polite, almost innocuous, but precise. I asked for clarification on minor inconsistencies I had found: dates, signatures, permit cross-references. Within days, a formal response arrived, defensive in tone, acknowledging the oversight but attempting to downplay it. I smiled. The trap was beginning to spring. Finally, I set my long-term plan into motion. It involved multiple filings, a few well-timed notices of claim, and discreetly alerting the county to potential violations that had gone unnoticed. Each action was small on its own, but designed to accumulate into a wave too powerful to ignore. The HOA thought they were untouchable. In reality, they were dancing on the edge of a legal avalanche that I had been quietly assembling for years. By the end of the month, I wasn't just a homeowner seeking restitution. I had become a force, methodical, deliberate, and in control. The demolition of my cabin had been the spark. My patient work, careful planning, and subtle manipulation of legal instruments had built a framework where justice was inevitable. And I knew, with a cold certainty, that when the day came to confront them, The HOA would finally see that underestimating me had been their gravest mistake. The next phase would be decisive, public, and irreversible. The first domino was about to fall. The first strike wasn't cinematic. There was no dramatic courtroom scene with gavel bangs and thunderous applause. It was a stapled packet and a certified mail receipt, cold and precise enough to feel like a scalpel. I signed for my own letter at the post office, watched the clerk slide the envelope into the outgoing bin, and felt a little thrill at the sound it made. Small, bureaucratic, and irrevocable. My filings were surgical by design. I opened with a notice of claim against the HOA for unlawful demolition, attaching the photocopies of the faulty consent forms, the suspicious notary images, and my grandfather's conservation covenant. The language was formal and paper-thin with legal restraint. Allegations laid out in careful chronological order, each paragraph footnoted with the document that supported it. No rhetoric, no invective, only what could be proven on paper. I followed that with mechanics' liens on the contractor who'd hauled away the wood. The invoices I'd acquired from a whistleblower showed inflated charges and line items that made no sense. Structural remediation on a structure that hadn't been inspected. Site clearing billed to a parcel that was already bare. The mechanics' lien was the kind of practical pain that hits payroll managers and accountants where they live. It didn't seek to ruin anyone, but it forced an answer. Money matters make people respond. At the same time, I filed a petition with the county to rescind the demolition permit on grounds of improper notarization and misrepresentation of consent. Procedurally, that moved the issue into an administrative hearing, a place where the HOA would have to stand before an impartial body and explain its paperwork. I knew administrative divisions tended to be conservative, even bureaucratic, but they were also allergic to procedural errors. My entire strategy hinged on turning sloppy arrogance into procedural disaster. The HOA's first reaction was arrogance wrapped in PR. They sent out an email to homeowners that morning. The subject line a smug clarification on recent actions. The message was carefully worded. They had acted within the scope of authority. They regretted any distress, and they were open to constructive dialogue. I smiled at that last phrase. It read like a parent's reprimand masked as concern. They thought a polished memo could close a grove of legal problems. Then the certified mail arrived. Board members stood around the clubhouse like a flock of startled birds, clutching envelopes and reading aloud in tones that tried to blend indignation with authority. I drove by that afternoon and watched them. The president's face ashen when she realized the claim named her personally. The treasurer pacing and dialing numbers like a man whose spreadsheet just turned traitor. I felt a small private satisfaction seeing them deflate. Their composure was brittle, and the first legal papers were a deliberate tap on that fragile shell. Within days, their defenses shifted from PR to legal posturing. They hired an attorney with a storefront presence and a polished brochure. He sent me a polite but firm cease and desist for what he called harassing communications and scandalous accusations. The letter was mostly bluster, invective wrapped in legalese, meant to intimidate but not to answer the substance of my claims. I replied with calm requests for clarification, copying the county prosecutor and the local papers. That's the thing about paper wars. Every flippant legal threat makes another trail of documents, and those trails can be followed. The county responded to my petition faster than I expected. An administrative hearing was scheduled and notices posted on the courthouse bulletin board. This was my moment to shift from private pressure to public stage. I filed additional documentation, affidavits from neighbors who'd heard pre-demolition conversations in the clubhouse, time-stamped photographs from the site, and a sworn statement from a contractor who admitted he was told to move quickly and that the consent paperwork had been arranged through the HOA secretary. His words were cautious, leavened with fear. People who'd been complicit were suddenly terrified at the prospect of legal exposure. Public hearings in our county draw a kind of thin, local theater. Retirees with folding chairs, an older woman who always carries a clipboard, a couple of reporters from the regional paper. This one had a different edge. The room filled with homeowners who had come because this was suddenly no longer their problem, but everyone's. The board presented their case with a practiced polish, The contractor's counsel leaning forward with the quiet confidence of those who expected the ritual to end in their favor. Then I stood and spoke. I did not scream. I did not theatrically produce relics of the past. I told a story, short, factual, and restrained, about a cabin my grandfather built with calloused hands and a broken back, a place where my family buried their dead and argued over fishing nets. I showed the county the petition, the notarization oddities, the invoices, the affidavit from the contractor. I let the documents do the talking. When the attorney tried to interrupt, I produced the whistleblower's affidavit and watched as his composure fragmented under the weight of exposed fact. The hearing officer was patient, the kind of person who reads entire filing histories for pleasure. He asked direct, narrow questions. How had the consent been obtained? Who authorized the contractor? Was the notary present? The answers the HOA gave were slippery. By phone, delegated, on file. Their narrative unraveled in small, precise ways. They had forgotten the fundamental rule of administrative proceedings. Records speak louder than recollections. By the time the hearing adjourned, the officer had ordered an immediate pause on similar demolitions and had referred the notarization to the county prosecutor for potential fraud review. That was the legal equivalent of a warning shot. Automatic stays, inquiries, and audits. The HOA's plan to make the cabin a cautionary tale had been turned into a full-scale investigation into their governance. The discovery process proved even better. Under court order, the HOA had to produce internal emails, minutes, and vendor contracts. The documents were a slow, inexorable drip-drip of self-incrimination. There were emails where the president joked about clearing out the eyesores, and an exchange between board members discussing making examples of non-compliant owners. There were drafts of bylaws with handwriting in the margins, amendments introduced after closed-door meetings, strangely tailored to solve problems with particular properties. It was a little like watching flies caught in amber. The more they flailed, the more perfectly preserved they became. When I subpoenaed the contractor's payment records, the numbers told a story of vendors paid at above-market rates and invoices routed through a small LLC that shared a P.O. box with one of the board members' businesses. That link was a thread I pulled at relentlessly. I didn't shout corruption. I simply demanded receipts and explanations. Each document they produced required another follow-up, another narrowly tailored request. They were drowning in their own paperwork. Community reaction shifted. At first there were whispers. Maybe they were right to clean up. But as more pages were printed and more affidavits entered the public record, the mood changed. Neighbors who had once been silent sent me photographs of minor infractions the HOA had ignored. Festering porches, untrimmed trees, items that contradicted the board's claim of impartial enforcement. People realized this was not a simple enforcement issue. It was a pattern of selective application and personal gain. A few homeowners began to openly question the board at meetings. That cracked the veneer of community compliance. I was careful, though. I never wanted to look like a vendetta artist. My motions were narrow, framed in civic language, and aimed at specific acts: a rescission of a permit, an audit of HOA procurement, restitution for illegal demolition. That restraint forced the legal system to respond in its own formal language, and formal responses generate records. Records are the currency of accountability. The first real blow came in the form of a civil injunction. A judge, after reading months of filings and evidence, issued a temporary restraining order against the HOA's ability to issue further demolition notices or to enter private properties without written and notarized homeowner consent. It was not a final judgment, but it was a legal cordon around their most aggressive practice. For the board, it was a suffocating constraint. For me, it was proof that a quiet, methodical assault on procedural errors could yield immediate practical results. That same week, news outlets picked up the story. The headline in the regional paper was careful. Local HOA faces scrutiny after contested demolition, but the lead paragraph quoted the contractor's affidavit and noted the prosecutor's inquiry into alleged notarization fraud. The optics mattered. Suddenly, the board members weren't just dealing with angry neighbors. They were dealing with reputational damage. Invitations declined. Golf games canceled. The search for plausible deniability became a public relations scramble. As pressure mounted, the HOA fired back with threats of countersuits, proclamations of community safety, and legal retorts that attempted to shift blame. They tried to portray me as a troublemaker out to disrupt harmony. That narrative had legs for a while, until the discovery materials revealed that the HOA's so-called safety memos had been drafted in the same email thread as a vendor's bid to clear several problem properties for future development. The links were messy and human, greed woven with complacency, and complacency woven with the desire to control. One evening, after a long day of depositions and document hunting, I sat outside the motel and watched the lake where the cabin had once stood. A breeze caught the blacktop and carried with it fragments of paper from the courthouse, certified mail receipts, photocopied affidavits, docket entries, all fluttering toward an uncertain horizon. The legal moves I had made were not glamorous, but they were effective. I had turned the machinery of government, slow, plodding, methodical, into an engine of accountability. The HOA's initial assumption that they could act with impunity had been their undoing. The same systems they had bent to their will had begun to bend them into submission. The battle wasn't over. I knew the HOA would fight back with every PR tactic and legal crutch it could find. They had access to money and social influence, but I had patience, precision, and a lattice of documents that made allegations stick. The first strike had shown them that taking my home had a price far greater than they'd imagined. The next moves would push that price higher, not vengeance for vengeance's sake, but restitution, accountability, and a precedent so clear that others would think twice before swinging a bulldozer at someone else's history. The HOA had expected me to simmer down after the first legal strikes, but what they didn't understand was patience. I wasn't reacting emotionally. I was building a crescendo. By now, their mistakes, combined with my careful documentation, had turned their own operations against them. Every filing, every email, every notarized form became a weapon in my arsenal. I began coordinating multiple legal avenues simultaneously. While the civil injunction prevented further demolition, I filed claims for restitution, invoking both state property laws and obscure county ordinances that had been long forgotten. My research revealed that each board member had inadvertently signed agreements, disclosures, or consents that tied them personally to the HOA's actions. Suddenly, liability was no longer abstract. It was personal. Meanwhile, the contractor who had carried out the demolition began to cooperate. His fear wasn't just about me. It was about the prosecutor's investigation into notarization fraud. He provided sworn statements detailing how the board had pressured him to ignore proper procedures. Every affidavit was meticulously cross-referenced with my evidence, creating an unbreakable chain. Public pressure mounted. Local news ran multiple segments showing my cabin's destruction, juxtaposed against HOA press releases boasting about community standards. Homeowners who had once been silent began attending meetings, asking pointed questions and challenging board decisions. Their discomfort fueled the sense of inevitability. The more they resisted, the more their inconsistencies were exposed. The legal showdown came to a head in the county courthouse. I had requested a full review of HOA operations and associated permits. Board members arrived confident yet uneasy. I presented my case with calm precision. A timeline of violations, notarization anomalies, inflated contractor invoices, and links between board members and shell companies. Each document was a brick, each affidavit a hammer. Their lawyers tried to interject, but every objection was met with pre-prepared counter-evidence. Witnesses I had quietly lined up, neighbors, former contractors, even disgruntled HOA employees, provided statements that corroborated my claims. The judge, an astute figure known for zero tolerance of procedural abuse, listened without interruption. By the time the day ended, the board was forced to admit several oversights and procedural violations. The air in the courtroom felt thick with the shock of their own miscalculations finally catching up. Simultaneously, I leveraged my county-wide influence. Documents showing my rights on adjacent properties and minor covenants that had gone unnoticed for years became points of leverage. I reminded the board through formal filings that any attempt to retaliate could trigger additional claims, potentially affecting their personal assets. The room, once their domain, had shifted. I controlled the narrative, the evidence, and the outcome. Every move was deliberate. My revenge wasn't about humiliation, it was about justice. The destruction of my cabin had been an unlawful act, but more importantly, it had revealed a system built on complacency and greed. The board's fall was methodical. It unfolded as each layer of bureaucracy, law, and human error was exposed and addressed. By the final hearing, the HOA had been stripped of their unilateral powers to manage properties without oversight. Restitution for my cabin's destruction was awarded, including funds for repair, lost sentimental value, and attorney costs. But the greater victory was structural. The county implemented new regulations to prevent similar abuses, ensuring no homeowner would face what I had endured. For the first time since the demolition, I felt the quiet relief of equilibrium. Justice had been meticulous, deliberate, and complete. The cabin's absence still ached, but it was no longer a symbol of loss. It was a testament to strategy, patience, and the power of leveraging knowledge against arrogance. The courtroom emptied slowly, leaving me alone with the weight of victory. The air smelled faintly of polished wood and paper, but it was the kind of calm that comes after storms, a silence heavy with finality. Outside, the county buzzed on with its usual rhythms. Cars idled at stoplights, lawnmowers hummed, and neighbors went about chores, unaware of the quiet reckoning that had just reshaped their governance. I didn't rush back to the lake. The cabin, as it had been, was gone. Splintered wood, torn shingles, and memories compressed into dust. But that loss had been transformed into something greater. Every legal maneuver, every filing, every carefully timed motion had become a monument to patience and strategy. I had turned bureaucracy into a weapon, not out of malice, but out of necessity. I realized that justice wasn't always loud. It was precise, patient, and unrelenting. Over the next few weeks, restitution funds arrived, and the county enacted new oversight protocols for HOAs. My name, once just a silent mark on minor easements and old covenants, had become a symbol of accountability. Neighbors began approaching me, shaking hands, sharing their own stories of minor injustices, seeking advice on navigating the labyrinth of local governance. It was strange, almost surreal. The power of knowledge and foresight extended beyond my personal revenge. It became a lesson for the community. I took a long drive along the lake, passing the plot where my cabin had stood. I imagined rebuilding, maybe restoring it to a newer, sturdier form, or perhaps leaving it as a marker. A reminder that arrogance can be challenged, and that the quiet, prepared, and observant often hold the greatest power. I thought about my grandfather, whose hand-hewn beams had stood for decades, who had warned me about underestimating bureaucracy and overestimating goodwill. I realized I hadn't just avenged a loss. I had honored a legacy. The HOA president moved away soon after the final judgments. The treasurer resigned. Contractors, wary of scrutiny, were more cautious. The lakefront community had shifted subtly but irrevocably. People now knew that overreach carries consequences, that procedural arrogance can be dismantled by knowledge, and that respect must be earned, not assumed. Sitting in a quiet cafe that evening, I reflected on the journey. I hadn't sought vengeance for the thrill of it. My motivation had been simple: to reclaim what was rightfully mine and ensure that no one else could suffer the same fate. In the end, the law, patience, and careful observation had been my allies. Power, I realized, often lies not in brute force, but in understanding, preparation, and timing. The moral of the story was clear: never underestimate the quiet, diligent, and observant. Those who bide their time, accumulate knowledge, and act with precision can turn even the smallest advantages into overwhelming victories. My cabin was gone, but justice had been served, complete, measured, and undeniable. And for anyone watching, the lesson lingered like the scent of pine on a late summer morning. Systems can be challenged. Arrogance can be corrected, and sometimes the quietest person in the room is the one holding all the leverage.